Welcome to Clue, Criminal Law for UK Enforcement. Imagine this, you did it. No excuses. Caught red-handed. But when the police try to charge you, they legally can't. Not because you're clever, and not because they messed up. There's a specific rule in UK law that blocks them, even if you're guilty. Want to know when the law lets you walk free? Stick around. You'll want to know this one. To understand when police can't charge you, we need to look at how offences are classified under UK law. There are three main categories: indictable, either way, and summary only. Each has different rules, different court routes, and different time limits. And one of them has a deadline. Miss it, and the case is dead. Let's start from the top and build up to where the loophole lives. Indictable offences. Indictable-only offences are the most serious crimes. Think murder, rape, robbery, or GBH with intent. These cases go straight to Crown Court. There is no time limit on charging someone for these. Police can investigate for years, sometimes decades, and still bring charges. Time doesn't protect you here. If the evidence appears later, you're still getting charged. Either way offences. Either way offences sit in the middle. They can be dealt with in either the Magistrates Court or the Crown Court. It depends on how serious the offence is and whether the defendant elects jury trial. Common examples include theft, actual bodily harm, ABH, and criminal damage. These offences do not have a time limit, so even years later, police can still make a charge. So, if indictable and either way offences can be charged years later, where does this mystery rule fit in? The answer lies in the third category of offences, summary-only offences. These are the smaller, less serious crimes, but they're also the ones that come with a legal ticking clock. And if that clock runs out before charges are laid, you're legally untouchable. Let's explain how. Summary offences. Summary-only offences are handled only in the Magistrates Court. These include drunk and disorderly, minor public order, common assault, and some driving offences. These are usually punished by fines or short jail time. But here's the twist. The law says these can only be charged within 6 months of the offence. Any time after this, and it's likely you can't be charged at all. The 6-month time limit. Section 127 of the Magistrates Courts Act 1980 sets the rule. For most summary offences, the CPS must lay information, in other words, begin court proceedings, within 6 months of the date of the offence. Not 6 months from being caught. Not 6 months from police discovering who did it. 6 months from when it happened. Miss it, and the case gets thrown out. Can police still arrest you? Now, here's the confusion. Yes, police can still arrest you after 6 months, especially if they don't realize the time has passed. You could be taken in, interviewed, even held overnight. But if the CPS didn't lay the charge in time, the court won't hear it. So you might still be arrested, but legally, nothing can come of it if the 6-month deadline was missed. Case closed. When does time start? That 6-month timer starts ticking from the date the offence was committed. Not from when police found out. Not from when you were ID'd. The moment it happened, the countdown begins. So if someone committed a summary offence in January, and police try to charge them in August, it's too late. Even if they've got CCTV, witnesses, or a confession, it won't matter. Case law. In R versus Birmingham Magistrates Court, ex parte Ahmed, 1995. The court threw out a summary offence because the CPS tried to prosecute after the 6-month deadline. Even though the offence was valid, the court had no jurisdiction to hear it. The law was clear. Under Section 127 of the Magistrates Courts Act, if this 6 months is missed, the case cannot go ahead, no matter what. This isn't a free pass. This isn't legal advice, and it's definitely not a free pass to commit summary offences and hope the CPS are slow. You can still be arrested. You can still be questioned. and if they act within time, you'll be prosecuted. But if that legal deadline runs out and they haven't charged you, you walk, even if you're 100% guilty. That's the rule, and it's written in law. Recap. Let's break down the 3 offence types in UK law. Indictable offences, the most serious, no time limit to prosecute, heard in Crown Court. Either way offences, mid-level crimes, no time limit, heard in Crown or Magistrates Court. Summary offences, minor offences that must be charged within 6 months and heard in Magistrates Court. CPS misses that deadline, the court can't hear the case. Thanks for watching. If there's a legal topic you'd like us to break down, drop a line in the comment section below. We're here to make the law clear, practical, and easy to understand. If this helped, give it a like and hit the subscribe button. Stay tuned for more videos. Keep learning, keep overstanding. Know the law, understand the offense. See you next time.